Aloha nerds, I'm Jessica Nguyen, head of Contract Nerds. You're about to watch a recorded session from our Contract Nerds webinar series, where we break down real-world contract issues with experienced practitioners from across the contracts community. This session was designed to be practical, not theoretical, so whether you're in-house, in legal ops, procurement, or just working closely with contracts, you should walk away with insights you can actually apply. You'll find the presentation slides and any bonus materials mentioned in this session linked in the description below. Let's get into it. Hello and welcome to our first webinar of 2026, folks, on AI Addendums, hosted by Contract Nerds and sponsored by DocuSign. As you all know, Contract Nerds is a special community because folks join from all over the world to learn and share their knowledge about contracts. Please share in the chat box, folks, where you're logging in from, and if you want to make new connections, please share your LinkedIn profile link. Let me introduce myself. I'm Jessica Nguyen. I'm the head of Contract Nerds and a deputy general counsel at DocuSign. Also, I'm a seasoned commercial attorney for about 20 years now. Contract Nerds, folks, is a blog, resource, and community dedicated to contracts. We provide practical, relevant, and expert-driven content through our website, our webinars, social media, and email newsletter with over 25,000 subscribers. If you're not yet subscribed to our newsletter, please subscribe. Hit the link in the chat so you can receive our weekly emails with tons of free content, tips, and resources for you. I'm thankful for y'all for being here, spending time with us, and being a part of the Contract Nerds community. All right, today's webinar topic, AI addendums, drafting, negotiating, and adapting to the new norm. We have two amazing speakers here with you today. You are in for a big treat. Please meet Laura Belmont and Matthew Kohel. Let me introduce you to our experts for today. Laura is the general counsel of Civis Analytics, where she leads the legal and compliance function. Previously, she was in-house counsel at Comcast, an associate at Latham & Watkins, and a staff attorney at Washington Lawyers Committee for Civil Rights. Now, Laura may look very familiar to you, Contract Nerds, because she is an award-winning Contract Nerds columnist on her column of AI and contracts. And she's also an awesome mom to two elementary-aged kids, one puppy, and a partridge in a pear tree. Matt is a partner at Saul, Ewing, and represents clients in commercial litigation, intellectual property matters, and with data privacy issues. Matt counsels companies that develop and use AI technology. And fun fact, folks, he is the author of the free AI addendum template that you'll receive today during the webinar and after the webinar as well. Thanks, Matt, for sharing a free contract template with us, nerds. We all love a good template. All right, a quick disclaimer from our friends in DocuSign Legal. Just an FYI, nerds, that this webinar is not legal advice and provided for educational and informational purposes only. Now, I'm excited to get started. But first, a quick word from our sponsor, DocuSign, who has made it possible to offer this webinar CLE to you all for free.
Over time, business got smarter, faster, easier, but the way we handle agreements is stuck in the past. The valuable information agreements contain is trapped inside static documents. These outdated systems and processes will cost time, opportunity, and nearly $2 trillion in global economic value. It's time to escape the agreement trap. Introducing Intelligent Agreement Management with DocuSign IAM, a new platform that makes every step of the agreement process smarter, accelerating revenue, reducing risk, and unlocking value. With IAM, the work of agreeing is done collaboratively on one intelligent platform. Anyone can create a contract with a drag-and-drop editor. Sales, automate contracting to close deals quickly. Procurement, Get your teams the tools they need fast. Want to delight customers? Create seamless customer experiences with automated workflows. No coding required. Signers get a smoother signing experience and concise agreement summaries powered by AI, allowing them to commit with confidence. And ID verification is fast, easy, and compliant. But the real power of IAM kicks in after the agreement is signed. Filter, search, and find key contract details. Empower teams with AI-enabled dashboards that analyze agreement data to uncover hidden risks and opportunities. It's all integrated with your business systems like CRM. Management made easy and smart. Intelligent agreement management takes agreements out of the digital filing cabinet and puts them to work for your business, transforming a business bottleneck into a catalyst for growth and efficiency. Unleash the power of agreements with DocuSign IAM.
Laura, take it away.
Hi, everyone. Super excited to be here today and talk about an issue that I know I have also been grappling with as a vendor who is incorporating AI features within my company's SaaS product, and also as a buyer who is using a number of SaaS products that are incorporating AI features. So we're going to get into the real contract nitty-gritty, but this slide, and I want to start with to ground us in this conversation as to why we're even here talking about AI addendum and why we need to think about new contract terms. So when we think about the existing SaaS agreements that we have, traditional SaaS contracts are just very different than what we're going to need in this AI world. And this slide, I want to highlight kind of three main differences. The first is traditional SaaS is something that's called kind of deterministic, which means input A is always going to lead to input B. When we're talking about AI, it's probabilistic, meaning input A is not always going to yield the same input. And that has very real contract implications. So something like thinking about what our SLAs look like and our performance guarantees. What do they look like when we can't guarantee and we don't know what the outcome is definitely going to look like? The second thing that we're trying to highlight here is just the real generative nature of AI. And we're focusing on these generative AI tools like LLMs, frontier models. So in traditional SaaS, when we're giving them our data, yes, we still have to worry about usage concerns, but there's new challenges here because they're not just processing the data. They're taking that data and then they're generating an output. So we have kind of new categories that we have to think about. Like what's happening with output? Who owns it? We know that there's training data. So definitely new challenges from what we've seen in traditional contracts. And then the third bullet that we really want to talk about here is just AI evolves. So when we're thinking about traditional SaaS contracts, it's pretty static. If there's an update, it's going to be controlled because, the team, the developers are updating the software. By its nature, AI is continually evolving and learning. And that has very real contract implications because we have to think about things like audit rights in a world where maybe a one-time check isn't going to tell us everything. We need to know more about what we should be expecting from a tool that has differences over time. So that's just to ground us. I want to just start with this framework because we really should be thinking about this as we move forward. And it's important because when we're talking about AI addendum, we're not just saying add totally new terms that you haven't thought about before. We're saying we need to go back and look at those terms like limitations of liability and indemnification that we know so well and think about how do they need to be adjusted to this new normal. This is another grounding slide before I turn it over to Matt. When we're thinking about AI addendum, the scenario that we're really talking about here is not, somebody is a customer contracting with a large language model like Anthropic or with OpenAI. We're talking about those scenarios where a SaaS vendor is adding AI features to their already existing product. And typically when that's happening, they're incorporating a third-party model. And so that's what we're doing at Civis in our platform. We have features that have Cohere's embed model, that have Anthropic's Claude model, that have different models embedded within it. And so when we're talking about contract addendum, we need to remember that there's not just one contract at play here. Yes, we here are talking about the agreement between a SaaS vendor and the customer, but we have to keep in mind that that SaaS vendor has another agreement, and that's with the AI developer. And a lot of the obligations that we can, as a vendor, agree to or can't agree to are because of flow downs or limitations with that original agreement. So, that is again just to ground us as we're talking, because throughout this conversation, we're going to talk about negotiation strategies. And this is just a really important point to keep in mind as we're moving forward. So, I'll turn it over to Matt.
All right, thank you, Laura. Thank you for that background as well. And that really helps set the stage for where we're going to be going today. And as I'm sure many of you have already negotiated AI agreements and come to realize that there's really no standard form of agreement. There are some evolving terms where there's some uniformity in the market about input ownership and training rights, et cetera. The same story holds with AI addendums, right? All the terms are not one size fits all, and they are use case specific, and they have to meet the technology and the company's use where they are. And so when you are either drafting your own AI addendum for internal use to share externally, or if you're in the middle of a negotiation, you get one and you say, this doesn't sound right, how can I push back? What should I be thinking about? Here on the screen are some of the big considerations that will inform your negotiation tactics, and also the terms that you're really going to push hard for, and where you might want to find some flexibility with the other side. And so you may have heard about all these AI bills and AI laws, and some states have 35 bills and one or two are passing a year, right? And so there are industry and regulation specific obligations. So we're talking about ones that may be AI specific laws, but also pre-existing ones where, for instance, you have a data privacy obligations, you're a regulated industry, you're subject to GLBA or HIPAA, and then you also have what some states like California are doing, or supplementing their existing regulations with AI-specific terms, right? California did this in October with its FIHA, it's for against algorithmic discrimination. So you really have to keep abreast of the evolving regulations, but also where your organization fits in and what those compliance obligations will look like when you are going to be implementing some AI features in a product. Understanding the use case, right? And I think that with every AI contract, even when you're starting from scratch and you're not negotiating an addenda, right? It's just a good practice to think down the road, right? What's the use case? What are the risks? Now, what are the protections I need, and what am I willing to give up? And let that governance perspective inform your contract negotiation. Data sensitivity, right? If you're going to be if you have a mature AI program and you're going to be doing some kind of code development project where you may want to be supplying customer data, your own proprietary data, you want to make sure all the appropriate protections are in the agreement and are meet the level of data sensitivity, if it's HIPAA protected information, et cetera, or if it's just, your trade secrets and things you really consider your secret sauce where your company finds value. You're going to have to think about how the data going to be used, who's going to have access to it, and what are the cybersecurity and other protections that are going to be in the addendum. The vendor proprietary model versus third-party LLM versus open source. As Laura mentioned, as companies' AI programs get more mature, it's really not as clear as it used to be. It's not as simple as we're going to sign an agreement and now we're going to onboard Copilot and that's it. A lot of the products that you're seeing are not licensed directly by the developer, and they are becoming more complicated. They may have multiple LLMs working in sequence. They may have a combination of open source data, open models. Some models claim to be open. Some companies advertise their models as open, but they may not be entirely. So you have to understand that, and you may want to provide some data, right? If you're going to do that, develop these proprietary models plus third party plus open source plus your data, you're going to want to understand what the consequences are. And we'll talk about this, like what happens at the end of the agreement, who owns these customized model. And these are all terms you're going to want to work through in the jurisdiction, right? What laws can and will apply. And you have to really understand, like, where is this AI feature going to be used? Because there are some very specific laws. Like one example is New York City's local law 144 on algorithmic discrimination requires bias audits. And we'll talk about audits and it only applies if, for instance, you have an office in New York, right? You're hiring in New York. So it may not apply if you're doing business outside of that specific jurisdiction. And of course you have all your other standard privacy laws, IP laws, and all the ones that are sort of AI specific and the amendments there too. And really the two bullet points at the bottom really sort of set the stage for how to think about this, right? What is the use case? How important is it to the business? How much do we want to push? What do we need? and what's the risk tolerance. And like every AI addendum, every contract, right, just like your AI policy is tailored to your company's needs, its business objectives, and its risk tolerance. Next slide, please. Oh,
It looks like we have a poll.
We do. Thank you, Clausy, for the little poll reminder. Folks, we have a poll for you that should be popping up. All right. Folks, do you mainly negotiate AI terms from the perspective of the customer or vendor? As you know, your preferred terms are really going to depend on your position as customer or vendor. So let's get a pulse of the folks here. And who do you represent more, AI vendor or AI customer? All right, it looks like it's a close one. It's a lot of people. It's going to be both, which that was my guess, right, Laura, before that when we were planning this presentation and Matt. But there's about 50% of folks though are just really thinking about this from a customer perspective. Really great insight. Thanks for answering, folks.
Wonderful. All right.
all right, diving back in. So, what are some of the key provisions in an AI addendum that we're going to be walking through today? And here's just an agenda to get everybody thinking about sort of the order of things, right, that you typically see in these kinds of documents. Of course, definitions, and we're going to do a deep dive into this, acceptable use policies. These are really the things that sort of set the stage, lay out the ground rules, right, define what is AI, what is not AI, who can do what, who owns what, etc. You know, 5, 6, and 7 really are there for the operational usage of the technology, and then your protections if and when something goes wrong, or if you want to do a routine audit for certain compliance reasons, where certain statutes and regulations are now requiring risk assessments, bias audits, etc. And then disclaimers, liability, and indemnity, what you can expect from a vendor, and how to try to do your best to really share that risk and the exposure, with a lot of the understanding that we don't know what's in the training data. We can't necessarily control how all users are using the system. The output, as Laura described, is not always going to be the same, right? You may get the same output as a different user on a very similar prompt, and there are IP considerations around that. And so we're going to look at it from those lenses there. All right, definitions. Let's move on. So one of the most important definitions is really defining what is artificial intelligence. What are the features that my addendum is going to be covering? And I think definition number one, not just because it's in alphabetical order, is defining the AI features, right? You have to advise the user what is the AI feature and how it is part of the existing services. And because it's a best practice to really disclose AI usage to users, even if you're putting this potentially on your website as an amended terms of service, for instance, right? You might have some certain disclosure obligations, but defining the AI features there's a couple ways of doing it, right? You may also want to define artificial intelligence separately from AI features, because at certain points in your agreement, you're going to refer to artificial intelligence, and you're going to see there really is no universal definition of artificial intelligence. So you're going to see terminology that references machine learning, large language models, neural networks, anything where it identifies that the system can do some kind of human reasoning or problem solving, make recommendations, identify patterns, be generative in nature, generate text, videos, software code, etc., make predictions. So really laying that out in the agreement is important, so you know what is an AI feature, what obligations and rights you have specific to your AI features, and if and when something goes wrong, what protections you have with respect to your AI features. And so here's some other definitions to consider. Some of these I think are pretty standard, like training, like what this means. And depending on what side of the negotiation you're on, right? If you're the customer, you're going to want very, very narrow training rights to the vendor, because you're protective of your data, you're protective of potentially other third-party data that you may be licensing and using here. Customer data, and one of the points that Laura raised, or Jessica raised, I believe earlier, was you have to really keep in mind the terms of the underlying agreement, right? And so when you're thinking about what is customer data, refer back to that underlying agreement, because there's a pretty good chance that customer data or company data is defined, and you want to make sure that your AI definitions complement it and don't conflict with it. And so here in italics are some of the highly contested areas in negotiation about what is considered customer data. So obviously the input data, right? You typically will own your prompts, but usage data, what does that really mean? You have to spell that out. metadata timestamps because there are certain artifacts related to the use of AI just through its generative processes, feedback data, performance data. And like, really, what does that mean, right? So, for instance, let's say you submit a prompt and you don't get a wonderful answer, but it's a good first start. And of course, in the natural course of things, you refine your prompt, you drill down a little further, you give the AI system more context, you're reminded of certain ground rules that you want it to follow, or all those kinds of things feedback, right? Is it just the initial prompt or how far down the prompt conversation do you go? So you really want to spell all that out, as well as AI output, or anything that is generated in response to your prompt is going to be AI output. And we'll talk about that in a minute, but who owns that is an important question, especially with all the IP rights around it sort of up in question in the US, and then trading. And look, and like I mentioned earlier, a lot of this is use case specific. So there are other definitions that you may want to include that will fit in what you're trying to do with your AI system. For instance, if you are co-developing a model, you may want to define something called the customer trained model and distinguish that from a provider trained model. So at the end of the agreement, you know who owns what and what obligations there are with models that have your data. And so sort of laying out all the definitions related to the AI features will help avoid confusion down the road if a problem does arise.
I think, Matt, this just really underscores the fact that clarity is really key here. It does not help either party to have vague references. And we're going to talk at the end about how to future-proof and make sure that you're not being too narrow in your definitions and how to do that. But this is really something that's important for both sides. So moving on to acceptable use policies. The first kind of comment to make here is going back to where we talked about there's really three parties at issue here. There's the AI developer, the deployer, who's the SaaS vendor, and the customer. From an acceptable use perspective, keep in mind that most of those requirements of the model, which you're incorporating into your tool, are going to flow down from the AI developer. So if you are using Claude has its own acceptable use policies. And if you go back and you look at their actual agreement and what agreement you would have with them, they're also going to say things like customer has to make sure that their end users and their customers are complying. So yes, it's like a great practice for us to say, okay, I want to make sure that people aren't using my product in a way that violates the AI developer's terms, but it's generally something that you're going to be contractually obligated to do if you're the SaaS vendor, of making sure that all of your AI vendors are following. So make sure you look at that. And some of them might be pretty prescriptive in terms of what language that you have to use, if you have to do any sort of specific disclaimers. So with that, the question, this is less of maybe a contract issue and maybe even a functional question, is how are you going to surface those acceptable uses to the customer? Are you going to update your own EULA and have it there? Are you going to be updating your kind of master services agreement or your customer agreement with the customer? Or are you going to, do a hyperlink on the UX of your product, which is saying, okay, you have to comply with these acceptable uses as well. So I don't think there is a best practice or a consistent way that people are doing this yet, but these are all different ways that kind of I've seen it done. And remember, when we're talking about AI from an acceptable use, the regulations that we've talked about are really focusing on high risk applications. So those are those applications that you're using to make really consequential decisions in the medical space, in the legal space, employment decisions. So those are where you're really going to need to be putting additional safeguards to the extent that you are adding it in to your actual agreement. And again, remember, these are not the same acceptable use policies as just traditional SaaS. So, there you're like, okay, we're not going to reverse engineer. We're not going to create derivatives. Here, we also have to think about things like not using output to make or train competing models. We have to worry about totally new concerns like prompt injection or kind of like putting jailbreaking. This is when you're kind of taking advantage of prompting and trying to trick a machine into giving you a certain answer. So remember, there are very new use cases here that may not be covered by your current acceptable use policy, and that you're going to have to make sure that you're incorporating everything that AI developer is focusing on. We'll go back to Matt.
All right, for the most fun topic in AI contract negotiation, data usage and ownership. And so there are really some key distinctions between data usage customer data, what is outputted by the AI system, and considerations to think about when you are engaging in a negotiation or the drafting of an AI addenda that distinguish the AI system from a traditional SaaS or a traditional software system, right? And so you typically see in agreements that customer data can be licensed to the vendor to develop or enhance products or for internal business purposes. That stands into distinction, right, for customer data not being able to be trained on for other purposes to develop an AI system. So you really have to, again, look back at your underlying agreement and understand the impact of those terms on this new project and these new features. And it's not just, right, AI is a little different depending on the nature of the technology. And we're going to say this a lot today, probably, but it's not just data that's inputted. It's not just your prompts that you may want to consider customer data, but also data that's accessed, right? And so, for instance, companies might be doing something called RAG or retrieval augmented generation, which is where you're setting up a little library or a little universe of documents outside of the LLM's sort of knowledge base, outside of its training data, for which the LLM will pull responses or will consult for information to formulate output, right? That is not technically necessarily inputted in a prompt, but is accessed by the system, and it could be supplied by, it will be supplied by the customer. It may have customer proprietary information. It may have data they've licensed from a third party. It may have publicly available information. So thinking about all those different aspects there.
Matt, can I add another example there?
Of course.
So ChatGPT and Claude, they added, right? We're familiar with just the chatbot function of like, we think, okay, I'm inputting something because I'm putting in a prompt, and maybe I'm attaching a document to that prompt. When they launched connectors, which probably many of you are using, which give context by connecting to underlying data sources like your Google Drive or other platforms, I went back to look at the definition because I was very concerned about this issue of like, is the data that's connected and being pulled in actually an input? And the way that OpenAI's definition of customer input, it says it's like information lowercase inputted. I'm like, well, that doesn't help. Like, is this accessed or inputted? So this is something, if even if you're not using a RAG model, a very common use case of connectors, of thinking about like, does this include that? Because I think a lot of the definitions, even say somebody created an AI addendum a year ago, we were only really thinking about the chatbot, right? Like enter a prompt, get an output. And now there's so many new use cases here. And it's really like system workflows. I see this one as being really important.
Yeah, I mean, I think what you're talking about too is Model Context Protocol, MCP, relatively new technology, but it's basically external databases for your LLM to talk to. And so it's data accessed as well. Those are great examples. Thank you for that, Laura. And you really have to understand the technology, right? You're not just a lawyer or a contract manager. Now you're also playing technologist by day, and so that ups the ante a little bit here as well. Some other considerations to think about, right? Would model training be considered an internal business purpose? Probably not. I would never take that position. I wouldn't agree with that. I don't think many on the customer side as well. Vendors want to allow for the use of aggregated or anonymized customer data. Well, AI is a little different, right? It has a much better ability to recreate proprietary information, has a much better ability to identify PII or individuals from large data sets. So that's just another consideration, something called the mosaic effect. It's really interesting use of AI to see patterns in data and recreate de-identified information. Allowing vendor use of usage data and performance data and feedback and all those things. But what does that really now mean? And how do you want to limit that? And not just the data that the vendor is going to have for those purposes, but how they can use it, right? Can they use it for developing their own model? Can they using it for developing third-party models, or really just to enhance and make better the services they're providing to you under the agreement? You have to delineate all those things in the agreement. And then, granting, again, vendors broad licenses. I think though for AI, you really have to circumscribe what the vendor can do with your data if you are very protective of it, and if it has trade secrets, non-public information, or other information that is sensitive or subject to regulation. All
And
right.
I'll add on this last bullet point too. So this I see the silent on how the developer is using yours as being a really key question that if it's not going to be flagged in the agreement itself, you should certainly be asking as part of your procurement process. So this is the idea that if, right, again, back to three parties being involved here, if I'm the SaaS vendor, maybe I am committing that I am not going to be using customers' data, right? Like me, Civis, is not going to be using customer data. But if it's getting sent to a third party model provider, what are they doing with it? What did I agree to in my contract? So this is definitely something that you want to drill down even, and some of this may not be spelled out or it might not be appropriate. There are questions to be having in an agreement, but there are things that you should be getting and asking as part of the procurement process.
And you also have to understand that too, because data that may not be yours, that you may be licensing from a third party that you want to use, may will be subject to certain restrictions, and you don't want to violate any of those contractual obligations. If the vendor is giving that data to its like sub processors to do something with it, right? You don't want to put yourself in hot water. You really need to understand sort of the chain of data custody throughout each step in the process here as best you can. Sometimes it's completely opaque. So that brings us to the next slide, right? Customer wish list. What in a perfect world, how would we like to negotiate our AI addendum from the customer side, right? Customer data clearly defined to include inputs, that your information you put in your prompts, but also accessed when you have or when the technology is going to be accessing certain data via connector, as Laura described. No use for model training and other purposes. Keep in mind that models can be enhanced, developed, customized, etc., not just through data training as that may be defined, as other ways that models can learn. And so you really want to be broad there in protecting how your data can be used. No anonymized or aggregated data use by vendor, although I think that you're going to get some pushback there. Maybe you get some other, representations about how they will or won't use it, or get representations of cybersecurity, for instance. And so I think as a customer, there is definitely some flexibility on the use of aggregated data by the vendor. And you can clarify, right, getting back to what are definitions, the importance of definitions, clarifying that feedback does not include prompts or inputs or even company data, user data, et cetera, if we really want to draw some lines there. And then same thing from the vendor, right? Definitional clarity is key. They want to understand their obligations. They want to know what they can use and how they can use it. Vendors are going to push back. They may say, okay, we get it. People are generally opposed to us using their data for training, but can we use it for other internal purposes, right? And you really need to think about what that means, how they're going to use it. And they want to push back and use, your anonymized and de-identified data, but do it in a way to make sure that it's going to be in a secure manner. They're not going to use it with any third parties. They're not going to sell your data. You really want to do it in conformance with the security standards that are in the underlying agreement and the best practices and other standards they set forth in their addenda, where they're going to make other representations about the nature of their model, the testing it's gone through, its validation, et cetera. All right, rolling right along to input ownership. Input and output ownership.
Just a few topics for today. I know we could talk about each one of these for hours. So thank you all as we're like kind of rushing through it so we can cover all of these. But this is like a law school exam where it's like, we just want you to be able to issue spot and then go. So now you can kind of come back to this deck or dig in other sessions.
Hi, nerds. Jessica again. Quick pause before we continue. If this session is helpful, I encourage you to subscribe to the Contract Nerds YouTube channel and newsletter. We regularly share full webinar recordings, practical contract breakdowns, info about free upcoming events and CLEs on contracts, along with conversations featuring contract professionals from around the world. Subscribing helps you stay up to date, and it also helps us continue to provide free, high-quality contract education for the community. You can also find the slides and bonus materials for this session linked below. All right, let's jump back in.
So I think the general practice, at least everything I've seen, is that the customer owns the inputs, right? Outputs, I think the customer wants them, although I've seen vendors take the initial position that no, we own the outputs and we get to use them and we'll assign them to you, right? To the extent provided by law. And what they're really saying there is that okay, there's really there's nothing to assign because you can't copyright AI generated output. So we'll let you use them for a lawful purpose, but we want to make sure we're not assigning anything. We're not making any representations and warranties about the IP protections in output. So we'll work with you. I think there's a lot of flexibility from the customer and the vendor side so that the customer can use outputs because outputs aren't necessarily just going to be, X plus Y equals Z, right? If that even makes sense. But you're going to get summaries, you're going to get analyses, you're going to get market research, and it's going to identify, derive new information for you that you hadn't probably thought of. And you're going to want to, if not own it, you may want to claim it as a trade secret, depending on the nature of your business. But if you're not going to be able to own it, you certainly want a license to use it for any lawful purpose, including for your business purposes. Um,
Matt, can I put you on the spot here and ask you, because I think even in other SaaS agreements, the concept of derivatives I find to be a tricky one. When we're talking about derivatives from a perspective of AI, so it's not just an output isn't a derivative. Like how should we think about derivatives?
well, I mean, I think of a derivative as anything that arises out of the original work. I mean, I assume we're not talking strictly like in the copyright sense, but derived data, right? Data that's derived from the inputs that are processed by the AI system. So it may lead to insights, right? If you have, for instance, there are certain AI tools where it may not just record your meeting, but it may give you bullet points. Like your R&D team was talking about X, Y, and Z. Here's some insights that you may have missed, or here, right? Let's put two and two together and get four for you. So you may it may. So I think of that as derivative derived data, insights, innovations arising out of the usage of the AI system. Because you can't patent AI output either, but you can certainly claim trade secret protection over it. So wherever you're going to want to do that as a customer, you're going to want to own it, at a minimum, have the right to use it. But really, the key takeaway here is in your definitions and in your terminology about customer usage, input ownership, output ownership, and usage of each one. Really have a wall between the ownership of the AI system, ownership of the data going into the machine, and who owns and how can the data comes out of the machine output be used. And of course, with input ownership too, right? The customer will own the inputs, but you're going to want to put in your addendum that you give the vendor a license to use the inputs, but solely to perform the services, solely for the performance of the AI features. And again, draw those lines around what you own, how the vendors can use it, and also how third parties can or cannot use your inputs. Third party IP claims. I'm on a roll here today. Good. So the big claim that everyone is concerned about, I'm sure everyone's seen the 45, is aware of the 45 litigations against OpenAI and Midjourney and all the other LLM providers, is copyright claims. And a lot of that arises from a few things, right? The training data, which will inform the output, and copyright claims arising out of the use of the output. And so the reality is that customers really don't have a sense of what is in the system's training data. Now, I think for a lot of the frontier models, the big names that Laura mentioned earlier, I think we can assume that it's basically data scraped off the internet, right? Including like social media feeds, user feeds. If you look at some of the copyright decisions, there's discussions about libraries of books. There are lawsuits involving, verbatim copying of the New York Times. So you have to really get a sense that it's anything that's freely available on the internet, plus other sourced data. And so because you don't have that insight into what's in the training data, customers should not, believe they should not be in a position to be sued for infringement, or if they are going to be sued for infringement, there'll be some protections in place because they would not expect that their output, right, which they're paying the service to generate, is going to include somebody else's copyrighted information, which they didn't want to put in their marketing materials, for instance. And so one of the complicated things is that as the technology continues to evolve, you're now having multiple models working in sequence, working on top of each other. And so you're dealing with many different data sets. And so customers are saying, we want to be protected if there's a claim of copyright infringement brought against us. And one of the key negotiating points that vendors have been willing to give up on is, okay, we'll indemnify you, we'll protect you, right? But not if there is willful infringement, because that's a user basically fault-based type thing. And so that's an issue there. So customer protection should not be capped as well, right? Because typically in the agreements, you might get liability protections or prior 12 months. Customers might want super caps. I know Laura's going to talk about that down the road. The vendors are going to push back, or they're going to say, look, customer protections, not if you misuse the output, not if you misuse the system, not if you put in a prompt designed intentionally to generate some kind of infringing marketing material. And, it may not even just be limited to copyright concerns, right? You may input a prompt that may lead to trademark infringement, which a lot of people are not talking about. But so human in the loop, right? And you'll see this in a lot of agreements that there's an expectation that the user will review the output before using it. Although I will say this, that recent statistics that I've seen from a number of surveys show that about over 60% of users don't review AI output before using it. Contrast that with about 50% of AI users trust AI. So half don't trust the system, and more than half are just taking it at face value and using it without checking
That's
it.
not lawyers and contracts. Right? Is that like Gen Pop? That's general population, or
I don't know. I don't know who all the respondents to the survey were, but it's a survey that I was aware that took place in 2025. So it's pretty interesting data. So human in the loop, it's almost it's as good as the paper is written on, seemingly in practice today. Um, And then the remedy, right? The vendors can say, well, we're not going to pay you damages. We're not going to indemnify you. We're just going to replace the model to a non-infringing model, make an update to avoid putting you in any hot water. And so there are areas of compromise, areas of shared responsibility for infringement that you can negotiate, right? The vendor should be responsible for the AI model and the training data because they control that, or at some level they control it if they're not directly the developer. The customer controls the prompt, and of course you can split on the output responsibility there, depending on maybe a finding of willful infringement, malicious use, et cetera, depending on the nature of the IP issue. All right, Laura, you're up.
Okay, that concludes our IP portion of this session. We'll be coming back to it though, because all of this comes back when we're talking about limitation of liability and indemnification. But we're going to focus now on some of the more operational pieces and talk about performance metrics. So when we started, that very first slide talked about, why AI is different than traditional SaaS agreements. And one of those things we talked about is kind of the probabilistic and deterministic. So that really impacts performance metrics. So when we're thinking about a deterministic output, the same input is the same output, what SaaS agreements are typically focusing on are things like uptime, right? Like I know I'm going to get this result. And so I want to make sure that 99.9% of the time the system is operating. It's kind of predictable. We know how long a response is going to take. It's a binary form of success. Like it works or it doesn't. And if it doesn't work, then there's a bug in the code and the team is going to go back and fix it. And if something is degrading, that's measurable and you go and you do an update. Like we said, AI is very different. So we're getting very different results. The response times aren't as predictable, right? Depending on how complicated a prompt is that you put into a system, it might take longer for it to process. And just being, having uptime working doesn't mean that you're going to get a response that's great and helpful to you. So that's going to impact performance metrics and how you're looking about that in the contract. So it's really it's going to be a balance between like, what are the customer expectations and how do we make sure that we're actually capturing AI performance accurately? So first on this, the left side is customer protections. As I said, uptime is not enough. Just the fact that an AI model is running and the feature is working isn't going to tell you very much about the actual performance of the tool. So customers are going to want to look at things like model performance and accuracy to the extent that you are operating in kind of a use case where accuracy can be measured. It's really difficult to measure accuracy. So you want to know, is the output factually correct? Is there a certain percentage at which you'd want to set accuracy and threshold? You want to make sure that there's low hallucination rates. So that's when we're talking about model performance and accuracy. Latency and response time, you probably generally want to know that if you are asking a question or executing a function, that it's going to be performed in a certain amount of time. Model maintenance and refresh. You're going to want to know about the model. is, right, we see with models that not only are models changing frequently, all the versions are getting updated a lot. We see there's 4.0 and 4.1 and 4.2, and that can change the way that your system is operating. And so you will probably want some transparency and visibility into any sort of maintenance and refresh to the extent it's going to change your outputs. And then as we talked about bias and fairness metrics, you're going to want to know, what are the thresholds for measuring bias? The vendor response is really going to be like, we said this is a black box, right? Like, I'm a SaaS vendor. I don't know. I can only tell you what I have from this AI developer. And so we really have to think about, as the SaaS vendor, what can we compromise on? And so I like to think about all these obligations should really focus on what can you control? What can I control, or what is in somebody else's control? And that's even true to the extent that a user is putting a prompt in. So what can I monitor about this feature? What can I tell you that I am learning from the AI developer? If there is going to be a model refresh, if I am aware of performance issues, I can communicate them to you in a certain amount of time. To the extent I know, I can give you notice in a certain amount of time. But the vendors are really going to be pushing back on any sort of like real absolute guarantees from an accuracy perspective and a prediction perspective, because that is just, right? Like, this is a feature, not a bug of AI. And so unpredictability is something that we all, unfortunately, just have to become a little bit comfortable with. So that was customer protections. From a vendor protection side, the things that I want to make sure that I am allowed to do as a vendor is I want to be able to offer my clients kind of a feature using a model that is best suited for their work. So I want to be able to modify my feature. I want to be able to swap out for a different model that maybe is performing better. I want to be able to retrain. And so I think it's like the best practice for both parties is your agreements should not be identifying like a specific third-party vendor. I would not, as either party, want to be locked into a feature that has a given model or a given version. I want there to be flexibility to change. And I don't want, as a vendor, to be liable for changes in AI performance when predictability is, right, always going to be an issue. And so I think a good compromise here is a certain amount of notice. If you, within your control as the SaaS vendor, are changing a model, and again, I'm not saying pre-approval, but some sort of notice. And at a minimum, as a customer, I say, I'm going to want to know if your change in model is fundamentally changing either access to my data or performance. So say I, as a SaaS vendor, have an agreement with ChatGPT and ChatGPT, and we have a certain agreement that says what can be done with that data. If I change and use a different provider and it's going to impact how my customers' data is going to be used, they have a right to know that, right? They agreed to certain terms or certain representations that I made. I need to make sure that, I'm sticking to that. Then I think a good compromise position is maybe I don't always have to tell you as the vendor about when I'm making these changes, but like there should be trigger points where certain notification or information is provided. So if certain performance metrics are falling below an SLA, that's when I should be telling you about these things. And I, as a customer, maybe want an out for that if, right, like a termination, that if performance is falling because of one of these changes, not just necessarily because of the way that the AI that I agreed to is operating, that I could get out of that agreement. Another one that is kind of like from an operational perspective is thinking about transparency and audit rights. So I do want to say, as kind of like the overarching thought when we're talking about transparency and audit, is going back to what we said before, that use case is really driving regulatory obligations. So if you're looking at the EU Act or other, right, EU AI Act or other state rules, and even New York, the main obligations relating to transparency and audit are going to be for those high-risk systems that are making consequential decisions. So part of that also, it is very prescriptive of saying who has to provide certain information and who is doing what. So if you are in one of those high risk categories, especially, you should, and you know which rules are applying to your program, you should be looking at them to see exactly what the regulations are telling you that you have to do, because that's going to be the starting point for your contracts. But other things, I as a customer would say, if I want more transparency and audit, is look, like once a year audit, which is pretty typical in SaaS to say, okay, I'm going to do an audit once a year to make sure that we're in compliance with this agreement isn't enough, because as we talked about, it evolves and it learns. And so it's going to be changing. So I, as a customer, am going to want a lot more visibility into what's happening under the hood to the extent that it is impacting me. So I am going to want to know, what model are you using and what are those rights? I'm going to want to understand, again, to the extent that you as the vendor can give it to me, what is the performance monitoring? Or are you as a vendor doing your own monitoring separate from what the vendor is doing? Are you running internal security testing? What are you doing from incident reporting? And those are things that are within the vendor's control. I will say though, here, part of it again of like, when we think about how hard we want to push is your use case. Again, we could say these are like all the things that every customer should want. But if you're using a very kind of like inconsequential feature of a tool and you know that you're not putting confidential information into it, or if like, look, I don't have anybody on my team who's going to be reading performance monitoring cards. I don't have anybody who can like really evaluate this model card. You have to take those things into consideration, because there are so many different areas where we want to pull threads here and push, that this is one that is very use case specific, that like maybe you don't need all of this if you are not in a risky, situation, if your confidential data is not being entered. And then I'll say, okay, if I'm the vendor, I'm going to respond and say, like, yes, but, right? I can only tell you, again, what is within my control. So, what are things that seem reasonable? I should be able to give you a notification if there's an incident. Again, that has to like be aligned with the flow down from the AI developer if the issue is on their end, but that's a reasonable flow down. Maybe annual third-party security audits, right? Because we're used to security audits and SOC audits that are conducted by third parties. I should be maintaining documentation, at least about my instance of the model, and creating a model card that's telling you about known limitations and features. Things that I would not want to do is like give you a ton of real-time data and dashboards and access to that information. I don't want to give you notice to like every incremental change that I'm making. This is just like really onerous on teams that I think even as customers, we could agree we would rather them focusing on kind of other things if we're talking about development and quality output, as opposed to like giving us a lot of information that maybe we don't even really care about. This is back to you, Matt.
All right, disclaimers and warranties. So I guess the long story short is that the anything goes wrong with the AI or the output, it's on you. Next slide, please. All jokes aside, I think that the disclaimers you're seeing are from the vendor side are significant, right? They're very similar to what you've seen in traditional SaaS agreements. You take it as is, no warranties of non-infringement, all sorts of things. But you're also getting some AI specific disclaimers, right? Obviously, that's the theme today, right? The AI specific terms for your addendum, but disclaiming accuracy, completeness, reliability, and use of output, right? So not just the content that the user is generating, but how the user is using that information. Because some of the concerns we talked about earlier, infringement, data privacy violations, et cetera. Disclaiming high risk and similar uses, right? So employment practices, applications for essential services, housing, insurance, access to financial services, et cetera. You're going to see disclaimers that the AI system is not going to create any kind of special relationship with the user. So no fiduciary duties, no special relationships. It's going to disclaim, if you use our system, right, where this is not legal advice, not tax advice, not financial advice, right? Very, very clear that the user owns all the risk for the content of the output and its usage. Even though the output is subjective, necessarily, quality is subjective, that it's going, you might put in the same prompt twice and get different output just based on the very nature of these tools. Um, and so from the customer side, you should expect to see, in addition to your, traditional disclaimers, a lot of very robust AI specific disclaimers. Now you can match those, right? And Laura was talking about sort of the nature of the AI system and the remedies you're going to seek, right? And so the vendor may say, okay, well, look, this is an AI system. It's you get probabilistic outcomes. Well, maybe you don't get one bad output doesn't result in the opportunity to fix something. You might have to see how this plays out over certain period of time or after a certain number of prompts to really trigger a customer protection, whether it's an audit or some kind of switching to a different model. Um, and look, on the customer side, you don't want to get reps and warranties that protect you. You're going to add language like AI system complies with all applicable laws. You may add language like AI laws. You may want to reference specific statutes if you're using it for a specific use, like employment practices. You want to get reps and warranties that the AI system has been validated. There's been some kind of effort to mitigate bias, that there are cybersecurity protections in place, that is designed to avoid giving responses, that's programmed to design giving certain responses to bad actors, such as jailbreaking, which is trying to get the system prompt or trying to get credit card numbers or some other kind of sensitive data that a hacker may try to get. And of course, that the AI system meets industry standards or even specific contractual terms, performance terms. And that way you have like an objective baseline to measure them against, 88% accuracy over X period of time, right? You can say, okay, you can track it and say the performance has degraded over a certain period of time or, dropped on this day. And then you can work with your vendor to remedy that. So, in response to you're taking everything as is, including just how you're using it. You really want to get reps and warranties so that the vendor will stand behind the service and the product that they're providing. All right.
All right, limitation of liability. Just again, we know this, but to briefly touch upon the fact that there are so many new novel liability scenarios here, and there's so much new risk. And so when we're talking about limitations of liability, start by thinking about this is an entirely new risk landscape when we're talking about software. There's inaccuracies, there's hallucinations, there's bias, potential bias in outputs, there's potential defamation claims based on an output. So we are talking about a riskier landscape, which still very much is playing by the old rules when we're talking about, you take it as is, no consequential damages, and capping fees at 12 months paid and payable. So if I'm looking at that kind of general framework, so thinking about limitation of liability in three buckets, there's like, what's the cap amount, which right now for most of these is going to be 12 years pay or 12 months agreement, whatever paid or payable. What damages are included or excluded, and are there any carve outs? If I'm a customer, I'm going to want to carve out for either kind of unlimited or super cap AI specific terms. So sure, that limitation of liability that we have for the general software is fine, but if it's related to these very AI specific terms, I'm going to be wanting to put them under super cap or uncapped liability. I'm also really thinking about, okay, can I get consequential damages here? Most of the time, right? The big, large font prints say no. But when I'm thinking about AI and the downstream impacts of like impact on profits and lost profits, this to me is something that is pretty relevant. So I'm going to look at the different type of damages and say, for AI related risks, can I carve this out? And I'm going to want to look to carve out in my indemnity sections certain areas from limitation of liability. So maybe you're not going to give me these things in my limitation of liability, but my limitation of liability clause is going to carve out things that I'm indemnifying for. or being indemnified for. And so let's try to get them in indemnity clauses, which Matt's going to talk about. If I'm the vendor, I'm going to say, look, I get there's massive risk from AI, but I can't control it. Like, I'm not the model provider. The terms that I've been given are tight, right? Like, it's going to be, I just looked at Anthropics today, and it is very aggressive that they're not even indemnifying or covering limitation of liability for willfulness. So, like, this is like very tight, right? From a flow down. I even wrote it down because I was like, that is so aggressive. So I'm going to say no, because generally here I don't have a lot of control. And it again is just thinking about that flow down, that this is creating a really tough scenario where you, as the SaaS vendor, can end up being responsible and holding the bag because you're not going to be able to go after the developer because you didn't agree to that, because you couldn't negotiate that. So I don't have a lot of answers for the customers here. I would love to hear in the chat what people have seen and what's been successful here. If your SaaS vendors have been kind of like agreeing to more than potentially they're getting from their AI provider, or, I think you'd be able to. Indemnification, because it always goes with limitation of liability.
Yeah, so the current state is that the developer and the deployer are not indemnifying from third-party claims arising from inherent LLM limitations. So hallucinations, biases, or other technological features of the product. However, there are some ways of dealing with it, especially with the biases. And so maybe go to the next slide. Is to talk about some of the AI specific indemnity provisions that are now finding their ways into AI contracts and even in AI addenda, because you're taking on new risks that arise from the AI output that you're going to be using, that your personnel are going to be using, that you may be sharing externally with third parties. And so you're going to want to push, if you're the customer, for the developer, for whoever your counterparty is to the agreement, to provide AI specific indemnification to you. Now, keep in mind, right, you've got this framework of three entities essentially in the chain of commerce. And if it's the deployer, they may say, well, we can't do that. We don't really know what's going on behind the scenes, or we're just a middleman. We don't even have the resources to do that. But really the concepts to think about are, from an AI identification perspective, if you're the customer, or what are the risks, right? You've obviously got the IP risk if the output that you've contracted for is infringing. And as Laura mentioned, right, there's definitely been some, I think, more recent pushback. I think originally, early on, I guess this is 2024, but if that's early on in the state of things, that you were getting indemnification from the AI providers, the large LLM providers, provided that the infringement was not found to be willful, right? I'm sort of thinking about copyright infringement there, but that was really it. But now, if you're the customer, you're going to want to push for things related for indemnification arising from the nature of the output itself. So defamation, right? That's one that was mentioned on an earlier slide. There's actually a lawsuit filed against OpenAI in Georgia, in which the AI system generated or created a false complaint, or said that somebody was accused of violating certain statutes and laws and were subject to a lawsuit or brought up on criminal charges, and they weren't, right? So that's why human in the loop is important. And the machines, the AI system, may hallucinate and make up false things about people or companies, disparage businesses. So you want to protect yourself if you can for defamation if you're the customer. Another one we talked about, so bias, was a challenging one, but if it's a high risk use, which you're using the AI system, or you might add something like protection or indemnification for violations of anti-discrimination laws or consumer protection laws, right? Because it's not just the AI laws that are now being passed, but you also have obligations from prior laws under like EEOC, FTC Act. So all those obligations still exist. And you've got to think, okay, now how can this AI our use case and the output result in new kinds of suits that we were not previously exposed to? So defamation, anti-discrimination, consumer protection, IP, depending on the nature of the AI tool and what you're using it for, right? Product liability protection, you may want to get indemnification for product liability issues. And so you really have to develop a outside of the box kind of AI indemnification paragraph that, as a customer, what are the risks that are going to arise from our use, And what am I seeing sort of in the news essentially for the kinds of cases and claims that are being alleged against AI vendors, like privacy, right? Following all applicable privacy rules, because who knows what's in the training data, right? It may have PII, it may have PII that's been licensed. It may have PII that the vendor may not have a right to use, right? So it's one of those reps and warranties, right? And in conjunction with whatever indemnities you can get, you're going to want to get reps and warranties, right, from the vendor that they have and will maintain the licenses that they to use the training data that's been ingested into the AI system. And then right in the middle, you've got the deployer, right? So there's only so much you can do there with that sort of middleman or the actual vendor providing the service, because they don't really know either. They may not have the resources of the OpenAI, the Anthropic, who can settle cases for billions of dollars. So it really is a give and take. And I think if you're the customer, you're going to have the most leverage, sort of tailoring the requested indemnification reasons to the risks that can arise from the use, and whatever information you can determine in the diligence process, right, about the model, whatever information you learned about it from demoing the product before actually signing the agreement. All of these information points and pieces of information will sort of inform how you negotiate indemnity, disclaimers, limitations on liability, et cetera.
And I think, Matt, to sum up a lot, like an underlying theme for all of these different provisions is going back to control of who has responsibility for the different pieces, what is within a different party's control, because that's going to be kind of a limiting factor as we're looking throughout the agreement. And there are all of these different actors, right? If something were to go wrong, somebody, right? Like it's hard to trace back to where it is, but it could be at all of these different levels. So just briefly on implementation, again, like as we said before, think about your risk profile, your case. These are the same things that you're doing for any contract, SaaS contract. Like what is your company's risk tolerance? Thinking about what are the regulatory concerns for your use case, for your company. A little bit more on the like actual operational. I think a lot of people, I have not seen a lot of AI addendums from vendors that we use at all. And I think there is this sense of holding off because things could change and there's not a market industry standard that we could point to. But I think for all of the reasons that we talked about, it makes a lot of sense to work on these and get something out now, but still thinking about, okay, how do we future-proof this addendum so we don't have to go back and make changes every time the rules change? So, and we can maybe adjust, I can send you some of these in the follow-up email so that the group has it, but you're going to add in things like, compliance with AI laws as amended from time to time, or like then current. You're going to talk about and reserving the right to kind of revisit with 30, 60-day notice. You should be, flexible about definition. So if you're defining high risk, you don't want just an exhaustive list. It should be including but not limited to, because regulations might add other sectors and other types of uses to what would be considered high risk. So there's these things that you can do, that understanding that technology is going to change. You can even add like a sentence about technology evolution, of like acknowledging that it's rapidly developing and, the parties will engage in good faith discussions if there's major developments or changes that would impact the agreement. So I think there's ways that you can kind of write that language into your agreement so that you can act now. And then there's another poll before we go.
Oh, I'm sorry, I just wanted to add one.
Oh, yeah.
Oh, go ahead, Matt.
I was going to say, as the customer, you should also really be thinking about if you haven't been given an AI addendum from your vendor, when the situation calls for you to proactively send one to the other side. If, for instance, you're in the middle of a development project and your developer says, hey, we're creating this multimedia, it would be great to use some kind of avatar or some kind of synthetic representation of an individual. Or if your personnel are using a system and they're like, wow, now we have this chatbot that's been enabled. I didn't even really opt in. And you learn that, right? You may have to proactively go to your counterparty and say, now we've got to address the AI features and the technology that have been incorporated that weren't part of the original scope and contract.
Absolutely. This is very simple. This shouldn't be totally new to us because I feel like we all did this with DPAs of
Oh,
like this whole idea too of how did you roll it out? What worked for your company of implementing? So again, like where do I start, right? A little bit of that paralysis. Look at your features, look for your high risk, prioritize, look at renewals, right? Like it's always a good way adding that language into your new SOW or your new order form and think about prioritizing it with your business people. But this is something we've done. We've done this before, right? This is not the
absolutely.
first time rules have changed.
Absolutely. And folks, the poll, does your company have an AI addendum template yet? Surprising, Laura and Matt, only a quarter of the vote said yes, they have an AI addendum template. So, hey, great that you're all here because for the 75% of folks who are drafting or putting one together very soon, you're going to get that free AI addendum template in the follow-up email tomorrow. So, really interesting stats. We're working on it right now. Very timely webinar.
And is this another poll? One more?
This is the same poll. Oh,
Okay.
and we have another poll coming up. All right. The last poll of the day, folks. How often do your vendors have AI addendum templates when they offer AI services or features? Uh-oh, Laura, you look disappointed with your vendors.
I'm
I'm getting a
surprised. I mean, I'm seeing so few. I'm honestly
huh.
surprised that people are seeing more and that many people had this already. I'm
I
seeing a huge lag with our vendors.
You're not alone. It looks like it's tracking about 80% of folks voting, of almost 400 votes, Laura, are saying that they have not seen an AI addendum from their vendors, which is shocking because as a vendor lawyer, I want to have the template, the starting point, and have the control of what the terms are and the risk are.
Absolutely. I would much rather use my paper.
Be sure to join us next month for our next CLE accredited webinar. It's going to be on a very exciting topic. I know you all are super pumped. Data security terms, which really go hand in hand with all the things we talked about today. All these AI vendors are processing our data. Are they doing so securely? And what those standards should be given the risk and the environment today. All right, stick around if you have some time. We do have some Q&A for our speakers today. Are you ready, Matt and Laura?
Yes.
Okay, let's.
All right. Uh, all right, folks. If a customer prohibits an AI vendor from using their data to train or improve the AI system of the vendor, how do you reconcile this restriction with an AI's product's need to inherently self-learn, continually improve, and train to deliver a great product for that customer? That's tough.
It's a great question. I think that's why it's so ingrained in us and me as well to say absolutely no, right? The first thing that we talk about with AI is like, are they using it to train a model? Are they using my data for these purposes? Um, but like it is as a vendor, like we like, right? The more data, the better. And it could, for me as a customer, get me a better product at the end. So I think part of that conversation is we're looking at it so much as like yes or no, you can opt in or opt out. And maybe there is that gray that we talked about a little bit more of if you can really anonymize the data, right? Or if it's aggregated, are there insights that can be gathered from it? Is there that happy medium where yes, like maybe I'm worried, right, about them using my training data because I don't want it to get spit back out to somebody else. So what are
Hmm.
those controls that will prevent that from happening? And I think as we start understanding more about the models and just how likely that scenario is where our input could get spit back out for an output or like, right, that granular data, we might start feeling a little bit comfortable with allowing more usage. But also, yeah, if it's not confidential or proprietary, again, I should feel like maybe I can toggle that feature off. Um, but when it's your data, like you're gonna say, you're like, oh, I hope everybody else lets them use their data, but not mine. So I totally appreciate kind of that stance.
And I think too, just with, it's not like the customer's data is the only data in town. Right, is the volume of customer data even enough to move the needle to really train a model? It's really not like training in the traditional sense, like pre-training. I mean, if you are co-developing something specific to you, you may want to allow that, obviously, but you'll take ownership of that customer trained model. But for the volume of data that to improve systems, to optimize them, I mean, vendors can curate data sets. They can create synthetic data sets, right? There are data brokers out there that are licensing data. They're scraping it off the web. So there are plenty of other sources for vendors to acquire and use data, beyond just their customers.
I do think though there might be we maybe will be seeing more of this in between because I know when people are talking about models, they're like, well, the whole internet's already been scraped, right? Like, what's the new data? And so if what the customer is giving is that new data that they don't already have access to, it becomes more valuable. So I will be curious to see if that pushes potentially like vendors to be more transparent in what those processes are because they want people to be opting in more.
I mean, they're going to start disclosing it pretty darn soon. California just passed a law requiring the
Mhm.
disclosure of training data. Maryland has a
Mhm.
similar bill. I believe New York has a similar bill. So you're going to start seeing a lot of disclosures of what is the training data, although in high level summaries, not, all the
Yep,
details, but you'll have a good sense of that relatively soon.
absolutely. Well, thank you, Matt and Laura, so much for sharing your knowledge and nerdiness with us today. And thank you to all the attendees for spending time with us to talk about AI addendums. If you enjoyed your time with us today, you're in luck because, again, we have another CLE webinar next month on February 26th. We'll be discussing data security terms and going deeper on that topic with great security experts. A quick thank you to our sponsor, DocuSign, who made the CLE program available to y'all for free. And last but not least, please subscribe to the Contract Nerds email newsletter and follow us on LinkedIn to get up to date contracting tips and learn of upcoming events. Aloha and stay nerdy.